She said there were discreet attempts to reach the court to explain the delicate nature.
Given a dictionary to define the word attempt.
Okay. What did you hear from the counsel for the 8th?
No, I will not withdraw. We are on live camera. They will play that clip if she says she didn't say it. But I've finished what I was saying to issue number 1. Let me go to number 2. You can go back to your note. She said there were discreet attempts.
Attempts?
Yes. Please, respect your office. It's
Well, I can't see it, but
so watacheza kwa Citizen jioni will hear it. So, number
I think Mr. Havi, you know, we are. This is a court of law. The public is watching.
Yes.
Kindly let that. As a judge, I can say that. Well, maybe it has missed. I have missed it, but I don't think I have heard that.
Okay, the court may not have heard.
I may not have heard that.
But we heard it.
And if there were discrete attempts, then I don't know where they were being made.
It's okay, my lord.
Yeah.
Could you allow me to go to number 2?
Let's proceed.
Yeah, I'm not apologizing, press. We're dealing with a serious enterprise here.
Since you are reading a statement,
Yes.
Is it in your statement that you are making discrete attempts to approach the court or something?
Hello?
What is it that you say so that it is clear for the record? Because I may not have captured each and every word.
Lord, if they can make a copy, they can supply a copy to the court of what they have said.
Yeah, let's find out.
I said there were discrete attempts.
We have a right to respond to the speech.
Give information to the court on national security matter, and I stand by that because national security matters cannot be written and cannot be said in public. And if it is a matter of national security, all 3 arms of government collapse into one, and it can be related.
All right, I didn't hear. I think then Mr. Abi is correct.
She has agreed, my lord. You know, she was reading, I was listening.
An attempt, you didn't.
Yeah, it was an attempt. An attempt is as serious as a committed action. So, my lord, permit me to finish. I'll be very short.
Yeah, proceed.
Yes. So the second fundamental issue I picked from written speech which she read, the submission, was that the heavy matters of national security demanded the presence of Mr. Gilbert Masengeli there, as opposed to what was otherwise personal tribulations that he was to meet in court. And my lord, this background is important. It is important for this reason. Lord, very early in the morning, we heard of reports published by none other than the President of the Law Society of Kenya, Madam Faith Moni Odhiambo, that the 3 petitioners had been released and dumped somewhere in Russia. There is a background to it. Just be patient.
they have been released. No, I'm from court. I'm not being able to see what is happening.
Yes.
What are you saying?
If you could just be patient, you'll get to hear what I'm saying. So, my Lord, it was our expectation today that the respondents will come and say, and we still expect them to say, that the first order for habeas corpus has been complied by us, and here before the court are the three. Relax. And if at all they have complied with the habeas corpus and produced the three, then this litigation will come to a natural end. So we'll be happy if we'll be told that is the case, because we've just seen this. Number two, my Lord, on the substance. Subsequent to the conviction and the sentence, Mr. Gilbert Masengeli approached the Court of Appeal on two civil applications.
Approach the Court of Appeal?
Yes, on two criminal applications. One is Nairobi criminal application number E466.
Criminal application number 466.
My Lord, if you could kindly ask them to be quiet, because I need to make these submissions in quietness.
Yes, let's maintain silence.
Yeah, it's not parliament or a public rally.
Yes, proceed.
Yeah, the first is criminal application number E466 of 2024. This criminal application seeks, in the main, to stay the order convicting Gilbert Masengeli of contempt of court. Number two, before the Court of Appeal, is criminal application number E471 of 2024. In this second criminal application, Gilbert Masengeli and the rest of the team have sought an order before the Court of Appeal to suspend and stay the sentence made by this court upon conviction. My Lord, indeed, these two applications were before the Court of Appeal yesterday. And they have been the Court of Appeal on Wednesday, the day before yesterday. And they have now been rescheduled for hearing next week, or a date that will be given by the President of the Court of Appeal. So, my Lord, the derivative from the developments at the Court of Appeal are this: that the Court of Appeal is now seized of the twin question of the conviction of Gilbert Masengeli and the sentencing of Gilbert Masengeli. And for that reason, Lord, the jurisdiction that this court had can only await the Court of Appeal's decision on those two applications. Further, my Lord, those developments before the Court of Appeal have an impact on the suspended nature of the sentence this court meted on Gilbert Masengeli. The nature of that suspended sentence is therefore before the Court of Appeals. So, my Lord, with those circumstances, this court can only do two things. One is to hear from Gilbert Masengeli on how he has complied with the order for habeas corpus, because he's here. And if he has complied, as we have read, then of necessity, these proceedings must terminate. Or if they don't terminate, then they must be held in abeyance, awaiting the outcome of the challenge against the order for conviction and the order of sentencing. That, my Lord, in my humble submission, is what should happen today. I don't know whether any of my colleagues would like to speak.
No, from the petitioner side. Let's get a rejoinder from.
My Lord, the Vice President of the Law Society is here.
All right.
Let me put him on record first, and of necessity, he must speak. Just to say he has something, or if he doesn't have anything, then he will say as much.
Your name?
I must abide by
Okay, say something.
My Lord, the President Emeritus having a summary is what we have to say. Just for record, I was attending the admission of advocates, that is why I did not come in time. But as a law society, we are eager to see this matter concluded to its logical conclusion in the procedure and the framework that this court deems fit with the nature and the weight in our petition. That is all, my Lord.
My Lord, with your kind permission, the summary of what the Law Society of Kenya is saying is that this court is functional sufficient. It's already concluded this matter. It is pending before the Court of Appeal. And the moment it goes to Court of Appeal, the jurisdiction changes and the matter at the Court of Appeal has to be dispensed with first before the proceedings here roll. My Lord, the last one is that the issue of conduct of court has now been personalized between the judge and the convictee. And therefore, the convicted person has to comply first before they have audience of this court. They have to show that they have obeyed the court, then the court can hear them. Thank you, my Lord.
Mr. Miller.
Yes, my Lord, a brief reply. The one thing that we must take into account is the orders that this court gave on the 13th of September. The orders, my Lord, had a rider. And the rider was that Mr. Masengeli could avoid sentence if he appeared